Companies Act, Section 459, Power of Central Government or Tribunal to grant approvals, impose conditions, and prescribe fees. Section 459 of the Companies Act, 2013 sets out an important legal principle that governs how the central government and the National Company Law Tribunal, NCLT, or National Company Law Appellate Tribunal, NCLAT, exercise their authority when granting approvals, sanctions, exemptions, or directions under various provisions of the Act. This section ensures flexibility, administrative control, and accountability while dealing with company-related applications. This provision applies whenever the Act requires or authorizes either the government or the tribunal to intervene or grant permissions in corporate matters, such as restructuring, managerial appointments, exemptions, or modifications to statutory requirements. 1. Authority to grant approvals with conditions. If the central government or tribunal is required to accord approval, sanction, consent, confirmation, recognition, or issue any direction or exemption under the Act, then such approval or permission may be granted with conditions, limitations, or restrictions that the authority considers appropriate. This allows the government or tribunal to tailor its decisions to protect public interest, shareholder rights, business governance standards, and legal compliance. Furthermore, if any company violates the conditions, restrictions, or limitations imposed, the authority has the power to rescind, modify, or withdraw the approval or exemption granted earlier. This acts as a safeguard against misuse of approvals and ensures responsible compliance by companies. 2. Requirement of prescribed fees for applications. Any application made to the central government or tribunal for seeking approval, sanction, consent, confirmation, or recognition, requesting a direction or exemption, any other matter requiring formal governmental tribunal decision, must be accompanied by fees, as prescribed in the rules. The purpose of this requirement is to create a formal, uniform process for submitting applications, accountability and proper administrative handling, fair contribution toward the cost of regulatory involvement. The Act permits different fee structures depending on the type of application, the nature of the decision requested, and the class or category of the company filing the application. This flexibility ensures that cost does not unfairly burden smaller or special category companies. Why Section 459 is significant? Ensures companies comply with conditions tied to approvals. Grants authorities the power to revoke permissions when misused. Prevents arbitrary requests by mandating fee payments. Supports structured and controlled execution of corporate law. Encourages due diligence before seeking statutory relaxations. Protects shareholders, creditors, and the public from potential harm. For more details, contact us.